Good morning, everyone, or good afternoon. Thank you for joining the CLE, the Insider's View and Summary, the 2026 legislative session, what passed and the effect on your practice. My name is Frank Pignanelli. I'm joined with my partner, Steve Styler, and our good friend, J.C. Skinner. Steve and J.C. and I serve as the lobbyists for the Utah Bar up at the legislature and throughout the year in different matters. I'm very honored to represent the bar and represent all of our colleagues. I do want to state that we are very grateful for the loyal legislators that serve up at the state capitol. They do a great job, not only serving their constituents in the state, but they really do a wonderful job of uh, interacting with their colleagues and also ensuring that access to justice was protected and also looking out to make sure that all the various interests are looked at. And they really do a wonderful job of examining proposed legislation and making sure that it does really will go in well with our judicial system and with the practice of law and how all of you represent your clients. So thank you for everyone for joining this CLE. This has become a great tradition. If you have any questions, you can go ahead and pop those in, and we'll have the legislators go through those as they go through each of the bills. We have a great opportunity here. Senator Todd Weiler, who's chairman of the Senate Judiciary Committee, has agreed to kind of act as moderator for all the bills and for all the loyal legislators that are participating today. We have 10 of those, so we're grateful for that. So, Senator, thank you for agreeing to do this, and I'll have you lead off.
All right. Thank you, Frank. I'm going to ask the legislators to go ahead and mute themselves on their audio until it's their turn to speak because some people in the comments are complaining that they're getting some echoing. So I don't know if that'll help. I also want to thank Michelle Oldroyd at the bar for her efforts in setting up this webinar. I'm going to start off by sharing my screen. And I think most of you are probably familiar with our legislative website, but I just want to show you we're at le.utah.gov. And if you come up to the bills section, the little tab up here, and come down to past bills, you can then do a search by word. So let's say you're interested in adoption. You could search for the word adoption here, and if I can spell, um, and it would take you to that keyword. Or you can just click on any of the bills. So I'm going to click on here, HB 11, dyed diesel fuel, and you can see the bill. You can see under status who voted for it. And most importantly, if you have a question on the bill, you can actually come down and listen to the debates and the audio from the Senate hearings. And also, legislators, I'm going to come back to this tab, but we have several legislators. And we're going to start off with Senator Cullimore. And and all of us are listed here. This is just under the legislators tab. Before we get to that, I do want to tell you our panel today, and you'll meet each of us. There's five House members and five senators, so we're very well balanced between the House and the Senate. We're not as well balanced. There's nine Republicans and one Democrat, and we love Grant Miller, and so we're going to let him probably talk a little bit extra, especially on some of the partisan or controversial bills. And we also have 10 men and zero women. And so don't hate us. I know that there were several female legislators invited to participate, and for whatever reason, that didn't happen, but that was not by design. So Senator Cullimore is the Senate Majority Leader. He's a practicing attorney, and he represents the Sandy area. And with that, Kirk, why don't you kick us off on some of the court bills?
Okay. Well, thanks, Todd. Yeah, Kirk Cullimore, Senate District 19, which is the southeast part of Salt Lake Valley. The first bill that we dealt with the courts was just adding to the court system. So we added two Supreme Court justices, two appellate court justices, and oh my gosh, I should remember this. Was it four district court justices, Todd?
Three. I think we ended up with three.
Um, and that was two in the third district and one in fourth. Is that right?
There's one in the third, one in the fourth, and one in the fifth in St. George.
Oh, okay. All right. Well, the session ends and my brain just clears of all things session related, and I get back to the private practice, I guess. But yeah, so that kicked off the session. That was one of our early bills. There were a number of other judicial bills. Obviously, I think on your slides, Todd, we're getting to a bunch of these, but we got judicial transparency, which will help not just lawyers, but the public at large access court records and hopefully upgrade the technology that the courts are using for filing and for again, hearing access and all of that. We didn't technically create new courts, but we created new processes for different types of hearings. We've got the constitutional court cases, and that's largely going to be cases that challenge the constitutionality of any past laws. Created a process where a party could remove those to what we're dubbing the constitutional court. But really, it's just a three judge panel made up of existing district court judges throughout the state. And the thought would be that any cases that would have statewide effect or potential constitutional challenges would get extra sets of eyes on them, and that of the three judges that are randomly selected for that panel, no more than you can only have one from any particular district, and so it gives a little bit more of a statewide input and more opportunity for judges across the state to weigh in on these types of cases where typically they're filed in the third district court, and so this would give judges across there. I saw a questionnaire, how do you pick the three judge panels? The courts actually collaborated a lot on this bill, and the idea was that the courts themselves would pick a number of judges from each of the districts that would be qualified, or not. I don't want to say qualified, it's not the right word, but they would pick what judges would be eligible to be on these panels from each of the districts, and then it would just be randomly selected with each case, and again with no more than one from any particular district. And then we also created a collection and housing court. And again, it's not necessarily a statutory court, rather it's changing process. And the idea, there was a lot of advocacy groups involved in this. The Utah Bar Foundation, this is really the result of a study from the Utah Bar Foundation and Access to Justice, finding that with virtual hearings, appearances by pro se litigants has substantially increased. And so we want to encourage that, and the ability for pro bono counsel to help these pro se litigants would be better served if we could consolidate this. And so cases would still be filed in the appropriate jurisdictions, but then they would be funneled to judicial assistance. So administratively funneled to a centralized location where most of the hearings could be had, pretrial hearings, occupancy hearings, probably even a number of motion and pleadings could be held there. And then if it required any substantial evidence or a trial, then it would be funneled back out to the court of the original jurisdiction. But that this would help not only the courts in efficiency, but also plaintiffs' attorneys, and also the defense counsel or defense counsels, defendants, and the pro bono to be able to help people statewide in this consolidated area. So,
all right, Kirk, why don't we bring Senator Brammer into the discussion? Senator Brammer is from Utah County, also a practicing attorney. He moved from the House to the Senate 2 years ago. And so we passed the three-court panel, and then at the end of the session, we also passed House Bill 366, which did make some modifications to that. Brady, would you be comfortable talking about a little bit about 366?
Sure. So it kind of goes in place with the panel. The panel was created largely, originally it was going to be a separate court that was where judges independently are chosen and selected and confirmed by the Senate specifically for that court. The courts and the bar, as I recall, requested that it stay with the district court judges. So it's not a separate court. It's kind of just within the current district courts. And so we accommodated that. There was also there was some concern with an over designation of cases into the court. So for example, if you're looking at like the sovereign citizen cases, I think everybody's seen a few of those floating around and things like that. There was a little bit of concern that way. But then after the court was created, and so we accommodated that, and that's what Senator Cullimore has described. Then there were challenges. There was a challenge on the basis that only the Attorney General could move cases into that, or the legislature or the governor, those that can represent the state as a whole. And so we adjusted that on the basis of the challenges to allow both parties to be able to remove it. We also, and then we put a backup in place that, we made a lot of these accommodations at the request of the court. So if there is a constitutional challenge, by constitution, the legislature can create new courts. And we said, okay, if for some reason this isn't, what we worked out with the courts, if the courts themselves find that it's not valid, then we're going to go back to the original plan of just having the constitutional court, which is separate from the district courts. I think everybody that was involved in the negotiation would prefer the system that was put in place, but we do have kind of a backup plan in the event. And we had fixed a few things that I don't think that they were, I don't think they were very valid challenges, but, I think that, anybody who has litigated knows that there's always you shouldn't be so certain on everything. And so we did modify and adjust those. And so that's kind of the backup plan, I guess.
And Kirk, did you want to add anything else on these court bills or 366 at the end of the session?
No, not at this time. Happy to answer questions, but let's let everybody else contribute.
All right, let's go to Grant Miller. Grant, you wanted to touch on House Bill 94, and so let's just do that now, and I'll bring the bill text up in a second. Grant is a public defender. He joined the legislature just a little over a year ago. And Grant, is it true that you're half Palestinian?
Yes, it is. That all got out on the last day of session. Even though it's no secret. My mother was born in Bethlehem, known for its hometown hero, but I can say that she was not born in a manger. But she grew up in Jerusalem, and the family ultimately wound up in the diaspora because of the occupation. Long story short, it was a more missionary that brought my family to Salt Lake City when I was 1 year old. My family landed here, but yes, first Palestinian American elected official in the state.
And Grant, since you're the only Democrat on the panel, I want to put you on the spot for a second. Do the legislators, the Republicans, Democrats, do they get along? Do they work collaboratively? Do they like each other? Are we like Congress, or are we like the Utah legislature? Could you just briefly touch on that?
I appreciate that, Senator Weiler. The Utah way is a real thing. It's sort of interesting to go up to the Hill and work collaboratively and then go home and turn on the news, and then all of a sudden there's stories of all this animus that never happened. But I do want to really commend my colleagues. I know I'm like the only member of the minority here. But as a freshman Democrat, across the two sessions that I participated in, was able to pass 6 bills into law, either as primary or floor sponsor, and I couldn't do that without the bipartisanship. I joke that bipartisanship is the best ship. But unlike other states where super minorities will not have a chance to participate in actual policy making, we do things very differently, and I do very much appreciate my friends on the other side of the aisle working collaboratively to focus on policy. And so thank you, Senator Weiler, for pointing that out. And I do want to articulate that I do appreciate the way that we do work here in the Utah way.
Thank you. I thought it would mean more if you said it than I did, and we did not rehearse that. But let's go back to House Bill 94 for a minute.
Yes, I don't want to take too much time, but this was a product of bipartisanship. Senator Weiler helped me pass this one. And this one, I want to just get the attention of all criminal practitioners, criminal defense attorneys, prosecutors, judges. What this bill does is that if there's a fine and your client or the defendant does required treatment classes, or substance abuse treatment, mental health treatment, evaluations, they could get dollar for dollar credit against the fine. We passed this law about a year ago, and there was a lot of questions from the bench about whether or not this applies to mandatory fines. And so we went back and we clarified that, yes, this does apply towards mandatory fines. So, for example, if someone's sentenced to DUI, which comes with mandatory fine and a whole collection of requirements to undergo treatment, That treatment can be credited towards a fine. Judge does have discretion about whether or not to allow that, and prosecutor has the ability to object if it's outside the interest of justice in a particular case. But I wanted to articulate that so that way, if there are any defendants out there, lawyers know that there are tools for people, particularly if there's a hardship or indigency or whatever the obstacle is. There's ways to help alleviate and focus on recovery and treatment than just be purely punitive and focus on the fine itself if need be. But appreciate the time to discuss that bill because it's meaningful to me and hopefully will help some people out there.
Thank you, Grant. And I just want to point out, as a freshman minority party Democrat, freshman or sophomore, it looks like you got one negative vote throughout the entire process. That bill almost passed unanimously. It did pass unanimously on the House and Senate floor. There was one negative vote in committee. So, and by the way, if you wanted more information, you could just go to the hearings tab and you could listen to the House floor debate or the Senate floor debate or the audio. It actually is video now too for the committee discussions. You usually get more meat in the committee discussions. All right, Grant, do you want to jump now to, if you don't mind, Representative Miller, I think we'll have you do House Bill 536, and I'll bring up the slideshow.
Thank you, Senator Weiler. I'm pulling up the 536 myself. This is the national parks or the protections bill, correct?
Yes.
Yeah, criminal conduct on public lands. This is a fun one because this is the first time that hoodoos are referenced in the state code. But what this does is it adds additional protections for naturally occurring elements of our public lands and other archaeological features like hoodoos, caves, petroglyphs, creates a fund to protect and preserve these things. And so we amended the state statute and the criminal offense of defacing by graffiti to allow for fines to be contributed towards a public lands restoration protection fund. So, for example, like down in Goblin Valley, you have all of these natural rock towers called hoodoos. And there have been issues where people either destroy them, push them over, and also if you go down to Sammerfell Swell or down in Moab, there's lots of petroglyphs, and unfortunately, a lot of people like to try to destroy those. And this fund will help preserve and protect sort of the natural and historic and antiquity beauty of the state. And it also allows us for the first time add the word hoodoo in our state code, which is kind of exciting. But that is a summary of HB 536.
All right. And I just want to show, if any of you are on your phones, you can't do that. But if any of you participants, if you want to point your camera at this, I don't know what you call these. It'll open you up to advanced law search on our website. You don't need this to do there. You can do that. But if you were to open that up on your camera, I'll leave it for another 5 seconds here if you want to do that. And then you can type in any keyword. So here, if you typed in hoodoo, it would then display from the advanced law search, it would then display this bill, which we just talked about. So I just want to show you some of the functionality there. Which is, I think, kind of fun. By the way, for those of you that don't know, we did build this new building over the past 3 years up at the Capitol. It opened in January. This is what it looks like. We call it the North Building. And in June, at the end of June, it will open on the...
your screen's not showing it.
Oh. Huh. Okay. Well, let me try to figure that out.
There you go.
Oh, is it showing it now? What's showing now, Kurt? Sorry.
Yeah.
It's showing like it's the presenter version.
Okay.
So
is that better?
So we still see it like where it says click to add notes.
Oh, okay.
It's
Well,
not
at least you can see something. I'll figure it out when the next person's talking. But they're opening a state art museum on the base level of this museum, of this new building at the end of June that you might want to check out, starting maybe July 1st. And then at the top of this building, they have this beautiful stained glass work that basically it includes elements from all 29 counties. And let's jump, if you're ready, Representative Nelson, let's just jump to House Bill 181.
Yes, thank you.
Representative Abbott. Nelson
you're
Abbott,
good.
sorry. I do
You're
that to
good.
you all the time.
All right, so HB 181. Sorry, I was expecting another one to come up, so just give me 1 second. Pull up my notes here. All right, so HB 181 is Uniform Estate Planning Amendments. So what this bill does is previously we've had, you can do a will by virtual or remote signature, or you can do a contract by virtual or remote signature. What you couldn't do was a trust or a power of attorney or other testamentary documents. And so this kind of cleans up that gap that we had in the law there and allows those to be done by remote signature as well. And so that's the bill. It's pretty short, pretty easy, but I think it's going to be a good impact for attorneys who do estate planning work, in that you don't always have to have the client come into the office for signatures. They can do it remotely.
All right. And then if those of you can tell me, if I jump down, do you see the slides moving?
Yes.
Yes. We're at
Okay.
Hoodoo right now.
Okay. So I'm going to jump down to Senate Bill 109 and Senate Bill 110. These were both my bills. And I was actually asked by some attorneys at a large law firm to consider banning both of these causes of action in Utah. And this was, especially 110, was controversial. But I was surprised when I started researching this. Utah was we are one of only 6 states that allows actions for alienation of affection. By the way, I'm getting some comments that my camera is fuzzy. I happen to crack my laptop screen right through the camera, so this is as good as it gets. Anyway, but so we're one of only 6 states, and I think most of you would agree with me that lawyers typically don't like to sue marital spouses for having affairs, and that judges typically don't enjoy handling those types of cases. And it seems to me that these alienation of affection cases are really only prospering in one state, and that's North Carolina. North Carolina seems to love one of these cases, and they had these types of cases. They had a high-profile $1.5 million verdict entered last year against a TikToker, and she was having an affair with like one of her social media managers. But Utah doesn't seem to like these. They're often what I was told was that you could be in a divorce mediation and you could be close to settling. And then, maybe the wife says, I'm just hypothetical. The wife says, well, I'm going to sue his mistress for $1 million for alienation of affection. So I want an extra $1 million to settle this case. And so these cases are rarely filed, but can be threatened that could, mess up a mediation. And if you don't know, these stem back to British common law, but they stem back to the medieval days when women were considered chattel of their husbands, and so if you improperly, use somebody else's chattel, you had to pay for that. That's the common law origins of this cause of action. So I did push back the repeal date until the first week of May next year. And so if you have a burning desire, or one of your client does, to sue a spouse for an affair, you still have a year. So I would encourage you to get going on it right now. The second one, common law marriage, very similar. We were only the second state. Well, I'm sorry. We are only we are one of 7 states that still allows actions for common law marriage. And many of you would probably, if you know our common law marriage statute, would say it's so hard to prove a common law marriage in Utah now, it's effectively already been banned. A little bit of history: the legislature banned common law marriages in 1925, and the idea behind a common law marriage was back in the rural days. Maybe it took a day and a half's horse ride to get to a justice of the peace, to get hitched, and maybe you couldn't leave the farm that long. And so we were just going to let people shack up together, and we would call them married if they held themselves out as husband and wife for 7 years. And so those issues were kind of resolved by 1925. So we banned the practice like most states did. And then in 1987, and I had to call Lyle Hilliard to get this history, we brought it back because the thought from the legislature was we could use it to crack down on welfare fraud. So 2 individuals who are living together and basically functioning as if they're married, but both collecting separate welfare benefits, that it could be used. So the state would be able to come in and say, well, you two are really married, so you shouldn't both independently qualify for welfare. Well, it was never used in that capacity from 1987 through today, and the laws changed on welfare benefits, and so anyways, this one also has a delayed implementation date. Um, this is also something that is threatened in mediation. Like maybe again, you have a couple who are divorced for, I'm sorry, married for 10 years, but lived together for 20. And so one of them might be saying, well, I want 20 years of alimony. And the other one says, well, we were only married for 10, but I could file a common law marriage action. And I think this would be especially relevant for same-sex couples if they were together before Obergefell or before Utah started recognizing those marriages. But even the feedback I got from the LGBT community is it's been a decade, it's time to move on. The other impact that this will have is there's a lot of creative immigration attorneys, and my hats are off to you, who are using Utah's common law marriage statute to kind of circumvent some of the federal rules on immigration. If people come here either legally or illegally without being married to someone, or they can't prove they were married, and this will have some immigration. That was not my motivation, but what I said to them is if immigration attorneys in New York and California and Texas and Florida can figure this out without common law marriage, which is the case, I think you can too. So let's next go to back to Senator Brammer for House Bill 591, which is nuisance amendments. Senator Brammer.
Yeah. Okay. So there's a couple of things on this. I'll wait for him to get. I think you went past it quite a bit.
Okay. Okay. Yeah, I did. So
in any event,
there we go.
The main point of this is we kind of had an odd statutory and common law nuisance framework. What this does is it says if you are a private party, you use private nuisance laws. If you are the state's attorney general, then you use the public nuisance law. And so it kind of consolidates everything into those separate legal concepts with private nuisance versus public nuisance. So if it bothers you, use the private nuisance. If it bothers everyone, then call Derek Brown to do the public nuisance issue.
All right.
And that joke was written for me by Todd. So.
Not true. Okay. Representative Loubet, also an attorney, represents, I think, the Sandy area, and has been in the legislature, I don't know how long, 4 or 5 years now. Let's go to you, Representative Loubet, for unauthorized practice of law, House Bill 260.
Excellent. So quick little explanation though. So I actually represent the west side of Salt Lake County.
Oh,
so
sorry.
Magna, west side of West Valley City, west side of Kearns, west side of West Jordan, Copperton. And I just finished my 4th year with the legislature. So House Bill 260 came up. I've had some cases personally where I've had family members, friends, sovereign citizens representing the defendant in a case, and they believe they have an understanding of the law, and in the process they file a lot of frivolous filings based off of things that are not actually legally based, and in the end it ends up hurting not only my client but actually the defendant, because they end up having to pay attorney's fees in a lot of these situations. And so I was having this concern. I was talking with somebody who's a member of the unauthorized practice of law committee with the bar, and they also expressed frustration with the way the current statute's set up. So under our Constitution, Article 8, Section 4, the Supreme Court governs the practice of law through rule. And they have the ability to discipline attorneys, but the Constitution doesn't talk about what happens to non-attorneys that are trying to practice law. So we've handled that through statute. And the statute that they were operating under said that they can enforce it through civil action. But what they were running up against is that because it was so broad, they didn't know what causes of action they could bring. They didn't know what remedies were available. They would seek injunctions, but they weren't sure what the elements of that were. So it was very challenging for them, and it became more of a letter that would come out from the UPL committee and saying, "Hey, please stop practicing law." And that was very problematic. And so we're working with them in the courts. We were able to really further develop and clarify the statute. So now it goes in. So if you're the attorney now and you have a situation like that, you can look at HB 260 and it'll tell you what things that you can do. So the court can do it by its own motion, or you can make a motion under this section to have that person removed. You shall have your attorney's fees awarded to put your client back in the same position they were prior to that intervening by that person who wasn't an attorney. And there's some other options that are available. It talks about when a referral is done to the bar, what their options are. It also creates a private right of action. So for some people, maybe a person that is having a estate plan done by somebody who's not an attorney, they now could have a cause of action if there was an injury to them. And then the last two more things. So one more thing we add was a criminal law component as well. A lot of states have it so that if somebody is out there practicing law without a license, there is a criminal element. And so for us, we have it where it's a Class A misdemeanor for the first offense, but for like major ones and ongoing offenses, it'll jump up to a third-degree felony. And then the last thing is we made it clear what the statute of limitations for these type of things are, because that was also an area of ambiguity. So that's what this bill did. And it's amazing to find out how many people believe that they can represent somebody without a license when you run a bill like this.
Including one of the legislators in the House, I heard.
Yeah, that was very surprising how many.
we won't name him publicly.
Yeah.
All right. Thank you, Representative Loubet. Let's jump to Senator McCall. And we're not going to do this a lot, but I want to touch Senator McCall, and maybe we'll have Senator Cullimore jump in with you on a bill that didn't pass. And we had two bills on the collateral source rule. Could you maybe just give a nutshell what the Supreme Court did last fall and what bills were touching on that subject?
Yeah, so and Senator Cullimore ran the bill. So Senate Bill 211 would take us back to a decision prior to 2000, prior to the end of the year. So Senate Bill 211 was an effort to have the collateral source rule in place. So the Supreme Court had a decision. It was the Gardner decision. They actually pulled some case law from California, the Howell decision, and eliminated or changed our version of collateral source rule. For those that don't practice in the injury space, that goes back to the amount paid versus the amount billed. Who should receive that discount? You get a discount when you have health insurance. And that's what that bill was. So Senator Cullimore did do a lot of work on Senate Bill 211. And what the idea is let's go back to the status quo prior to the Gardner decision, and let's keep the collateral source rule in place. With that, I'll defer to Senator Cullimore. He did a lot of work on this bill.
Kirk, what do you want to tell us about this issue? And tell us if you think it's coming back.
Yeah, I'll just say every year we tend to deal with some bills that, our appellate courts either invite the legislature to come in and better define law or upturn, longstanding practice like they did here. And so the Supreme Court upended the collateral source rule here in Utah, the way it's been understood for decades at least. And they even suggested, the legislature could act on this. And in fact, we have. It wasn't this session, but just the prior session. We define what the collateral source rule and how it can be used in medical malpractice, med mal claims. And so 211 was an effort to apply that to all tort law, particularly motor vehicle accidents and other injury type claims like that. It did not get passed there. It dominated most of my time during this legislative session, and that happens sometimes with certain policies. I think there's a compromise to be had, and in fact, I had various compromise bills, substitute bills drafted on this, and had been working those. I got some signals that didn't matter what we did this session, it did not look like we were going to have the support it needed to get all the way past. And so rather than continue to bludgeon myself and everybody else, we decided let's continue to work on this. So I do expect there'll be more efforts to address this in the future. What that looks like, I'm not exactly sure yet. I'm not sure if we'll just canonize the collateral source rule as it's been held in Utah up until this decision, or we're looking at a lot of other states, and some look at what evidence may be admitted after a judgment and then preclude that that the admissibility of that evidence to a jury and then just present it to a judge after a decision's been rendered. So there are some options for a middle ground. We'll continue to work on that, and I expect there'll probably be more bills until we find a resolution here.
And thank you. Senator Brammer, you want to jump in for a second with your comment?
Yeah, one of the interesting representations made by the insurance companies in committee and to various people was they believed that insurance premiums would decrease 11% because of the change by the Supreme Court. Color me a little dubious. I don't know that I fully buy that, but I look forward to seeing it, and we'll see this next year if everyone's insurance premiums on commercial and on typical consumer auto goes down 11% or not. So we'll see if they put their money where their mouth is.
Good point. Senator McCall, let's jump back to you for is it showing now? Senate Bill 235.
And I love the photo, Senator Weiler. When I went through the slide deck, I thought that was a classic. This was a bill that I worked on, and ultimately in the end, I got there was a lot of teamwork with Senator Brammer who helped me out in the end. This bill started by doing a salary increase for our Attorney General. I've watched the amount of work that goes into the Attorney General's office. The Attorney General prior to Senate Bill 235 in the state of Utah was paid about $174,000. And as we look at the landscape in the state of Utah, we look at what we're paying attorneys. There are a lot of associate attorneys in Salt Lake, a lot of associate attorneys across the state that are paid significantly more than our Attorney General. So we started with Senate Bill 235 as an effort to bump up that compensation. Ultimately, we collaborate with the House, and I think we do a really good job. There were some folks in the House that said, it doesn't feel appropriate to bump up the Attorney General more than the governor. The Attorney General, the $174,000 is 95% of the governor's salary. So the way our salaries are staggered for those constitutional officers, the governor makes 100% of his wage, which was about $184,000, and then the AG, Attorney General, makes 95% of that. The Lieutenant Governor, Auditor, and Treasurer all make 95% of that salary. Ultimately, we landed the bill by bumping up the governor's salary, which also brought up the Attorney General's salary. So we matched it with the Supreme Court Chief Justice, about $240,000. So the governor and the Chief Justice make about the same. Well, they do make the same in the state of Utah moving forward. But by bumping that salary up for the governor, it did bring up the Attorney General, who again makes 95% of the governor. The auditor, LG, treasurer make 90% of the governor, or 90% of the Supreme Court. So that's what the bill did.
All right. And for those of you that don't know, Representative McCall is married to Governor Cox's sister, and that's why I made him present this bill.
Well,
all right.
And ultimately I started, so to be fair for the audience, I started working on this bill with the Attorney General. That the House pushed hard, and they thought, we need to bring up everybody. We need to include the governor, and that's where we had some teamwork with Senator Brammer. My name came off of the bill. We still brokered a pretty good resolution, and I feel really good about where it landed.
All right. Thank you so much. We're going to jump now to Representative Shallenberger, who is also an attorney. And what do you want people to know about you, Representative?
Thanks, guys. I just finished my second session. I just replaced Senator Keven Stratton. He was in the House for several terms, and he moved over to the Senate. And so I replaced him down in Linden, Orem, and Provo. I went to BYU, graduated from law school at Willamette University up in the Northwest, but I do contract law and trademarks. And one bill I've worked on this session that impacts this area is a water bill with the State Water Engineer's Office, House Bill 60. And that really helped refine the role of the water engineer. She reviews her 16,000 water applications every year. Helps to narrow the scope because over the course of time, she's been tasked with not just reviewing water applications, but other layers that get piled on top of that: environmental impacts, socioeconomic impacts, air quality impacts, rezoning impacts in cities and counties, and even disputes on water boards. It was interesting as water applications came in, sometimes she would be asked to resolve a dispute between water board conflicts. So this bill really came in and said, your job as the state water engineer is to focus on quantity, quality, and availability, and then the beneficial use of water. So really focus on water. Your job as a water engineer is to do water engineering stuff. Let other experts focus on the other stuff. And that will help simplify the role of the state water engineer. And then it doesn't really affect protests. There was some pushback on this. People thought their right of protest was going to be taken away for different applications, but it does not affect anybody's right to protest a water application. In the words of one environmental group, Trout Unlimited, he said over the last 20 years, as he looks at every application they've protested, it's always been into one of those categories: quality, quantity, or availability. And so he's like, it wouldn't affect anything that we're doing. And then as far as disputing or not protesting, but as far as disputing or any of the litigation side with any water bills, it brings the water engineers, these applications, in line with state law, saying you need standing if you're actually going to try to bring any legal issue with a water application, whether it's regards to the Great Salt Lake or the Colorado River in rural Utah. So color me dubious, but you just need to be in line with the legal issues. You need standing if you're going to have any type of legal dispute, and that's that. So that was my big water bill for the year. We did have one landlord liability case that was similar to a same-sex dorm bill we had last year in the legislature. This dealt with off-campus housing, trying to make sure that when people are moving into either gender approved housing for male housing or female housing, that it's based off of birth sex. And that helps provide clarity for landlords, for the people that are moving in, as well as anybody on any side of that issue. So it helps provide some certainty on that one. So that's
all right. Thank you. And I'm going to ask you, I know it wasn't your bill, but can you also share with us about Senate Bill 229?
Oh, is that the land use?
No, that's the state employee benefit amendments.
No.
I'm sorry. I thought I texted you about that last night. This is just going to change how state
Do you want me to
employees.
talk about it, Todd?
Yeah, go ahead, Anthony.
So currently, the process has been the separation of your sick leave and your vacation time. And so if you're an employee that doesn't get sick, you can have a significant amount of sick time accrue. And when you leave, that is not compensated to you. That just kind of goes away. And so the HR, the Human Resource Management Division, what they were trying to do was create some sort of incentive. And so they combined the sick and vacation leave into one pool of paid time off, which is somewhat similar to what's going on in the private side. And then the number was reduced a little bit to compensate for the fact that now all of that was going to be monetized. The pushback came because if you are healthy, you benefited from this. And if you were really sick, personally, you would benefit because it also paid for short-term and long-term disability insurance. But if you had a chronic condition, which you had to leave, let's say you have MS, right? You could utilize your sick time, but under this new formula, you wouldn't have enough. And so there was this friction back and forth of whether or not people liked it or didn't like it. There were people that expressed support. There were employees that expressed concern based on their own personal situations, or if they had a family member who also got sick and had to take leave. And so what ended up happening is the bill came before the House, it died, and then it came back and allowed employees to choose that already were existing, which option, if they want to maintain the current separation of sick and paid time off, or they could switch over to the paid time off. And then any new employees would just start in this new system of the sick and vacation pooled together in this paid time off.
All right, thank you. Let's jump to Senator Stratton now. Keven,
Thanks, Representative Loubet. I was just about to say all that exact same stuff.
Excellent. Senator Stratton, you want to briefly introduce yourself?
Sure. It's great to be with you today. Been a member of the bar. I have a pretty low number, in the low 6,000s. But I would just, Todd, if I would just like to comment. I appreciate Representative Miller, his comment on the Utah way. As attorneys in the legislature, we're first of all an attorney, we're second a politician. Some people perceive you have 2 strikes against you before you can get up to bat, and so we just have one pitch. But it's really remarkable the contribution of the bar and what takes place on several of the bills that I've worked on through the years. It's a real blessing when I have not only colleagues but those that have that perspective. Very, very helpful. And so don't ever discount the difference you can make by weighing in and offering input. So grateful, and you have some great representation with JC and Frank, and just it's really good opportunity for the state. Todd, would you like me to talk? What would you like?
Yeah, let's have you jump into House Bill 195, Precious Metals Amendments, and I'll just kick this off by saying this bill was vetoed by the governor last year, basically the same bill, but it was not vetoed this year. So what can you tell us about that?
Really interesting. This is the one bill that the governor didn't sign. The governor can either sign or veto or choose not to sign. If they choose not to sign, it comes into law. And this is based on his concerns last year. He chose to not sign it this year. However, that was very appropriate. He's moved a little bit on this issue, but what the bill does, there's really, as we look at the landscape to monetary policy and what's taking place in this space, many of the experts in the nation, those who've served in high positions in former presidencies and in the executive branch, have recognized the need that we need to have various alternative opportunities for our monetary options. And what this bill does, it does several things, but directs the treasurer to seek, probably the biggest thing, to seek proposals to create an electronic payment system backed by physical gold or silver stored in Utah, which is really interesting. You might be interested that the highest return we've ever had in our resources that we have setting aside, our rainy day funds or whatever, is 2 years ago we directed the treasurer to place actually $100 million in gold reserves, and that yielded the highest return over the last 2 years that the state has seen on any investment. Quite remarkable. But with that success and what we're doing, this was an interesting bill. And actually, one of those times where it's voted on the House floor, and there were several that were not able to be there. They're off meeting and doing, and it came back. So it didn't pass the first readings, came back the second, was reheard and passed, and then came into law. So that's that bill.
All right, Keven, thank you so much. Can you now cover for us House Bill 235?
House Bill 235. Let me look at that real quick. You bet. I had.
Or is it 325?
Is it 325?
325. Yeah, sorry. The one on the screen.
Okay.
Sorry,
Thank you. 325. That's an interesting. There's a lot to this bill, but as it applies to what we're doing directly to some of our clients, it's a transparency clarification bill on our governmental records. It did. There was some fuzziness in certain areas on whether it be protected or not, privately or not, but went through specifically on this, talking about taxpayers, uh, uh, specific taxpayers' uh, privacy, protecting some of those things, and with some exemptions of whether the interest is in restricting the access is less than the need, or the interest favoring access, or greater than or equal to the interest favoring restricted access. But it also opens up, clarifies several other areas in our governmental records, subject to grandma and so forth, what would be appropriate and not, to create a more transparent and sustainable, stable, intentional approach in this space.
All right, wonderful. Thank you. The next bill is another one of mine, Senate Bill 218. I was actually approached by John Sent. Some of you have probably used him to serve your items and serve your different legal paperwork. And he had a couple ideas for a bill. And I passed it unanimously through the Senate last year, and it passed through the House committee. And then on the very last night, it was just one of those bills we didn't get to before midnight, so it failed. And so I ran it basically the same bill again this year. The big change here is if you're trying to collect a judgment, and we all know how difficult judgments are to collect, this would give the constable the ability maybe to come in to a debtor, and instead of taking their couch and their kitchen table and their kid's bed to set up a payment plan. Because, what are you going to do with that couch? Are you going to stick it in your law firm? I mean, you're going to sell it on KSL.com. Nobody really wants to do that. And so they can set up a payment plan. The constable can just stand there on their doorstep and say, look, I'm either going to take all your stuff or you're going to agree to a payment plan. It also requires them, if they're working outside of their jurisdiction. So let's say they were appointed as a constable in Utah County, but now they're serving process in Davis County. It would require them just to call the local sheriff in Davis County and say, hey, this is John Sent. I'm going to be working in, Centreville today, just so there's some coordination there. And that's all the bill really does. All right, next we have, I think we're back to you, Senator Brammer, on House Bill 242.
All right.
Is that showing on the screen now? Is 242 showing on the screen now?
Let me double check. Yeah, yes,
Okay.
it is. All right. So this one relates to initiative and referendum petitions. So typically, you have to gather those in person. They have to sign in person in the presence of another person. Removal is not as difficult, but there is no allowance for any kind of gift giving as part of it. And so there was an issue of whether or not stamps constituted a gift. And so, that this was one that essentially said, yes, that's a gift, so you can't include prepaid postage stamps. There had been a lawsuit pending, and what this did is it did not decide the issue looking backward, but it did say from this point moving forward, you have to do that without any kind of gift, even if it's a smaller amount like a stamp. So that's probably the biggest change.
All right, thank you. And next up, we have, we're back to Senator McCall, Senate Bill 194. If I can get that to show on the screen.
Yeah, thank you. Thank you, Todd. I just want to start by saying we've done a lot of work on elections over the last 2 years. A lot of work done the session before House Bill 300. For members of the bar, I think we've got some really good things going on with elections. There's a lot of confidence in the state of Utah. I think our lieutenant governor does a fantastic job. There's obviously been a lot of animosity with elections across the country, but when we look at polling in the state of Utah, I just want to be really clear that I've got a lot of confidence in what I've seen, but that doesn't mean we can't do better. So Senate Bill 194 is just an addition to the year before. How do we make elections better? What can we do to continue to enhance the process? So basically four key elements of the bill. The first thing we did in the bill is we've created a conflict of interest avoidance plan. So when when Spencer Cox was running the election for Governor Herbert, he brought in Greg Bell to oversee that office if there were if any kind of dispute. This same thing happened when Deidre Henderson, Lieutenant Governor, was running the election for Spencer Cox. We felt like it was important to put that in code and make sure we had a conflict of interest avoidance plan to give some confidence to the electorate. I don't know that ultimately there are going to be some folks that are never going to be satisfied. But if we're really trying to avoid the conflict of interest, that's what we did. We did a little add-on to House Bill 300 from the year before. When you receive your mail-in ballot and it's verified at your local clerk's office, we are now requiring that both your signature and the last four digits of the ID number that you use are both verified. We also dealt with county clerks. If a county clerk is counting signatures of an opponent, we want that conflict of interest to be resolved. We want them to contract out to other clerks. My least favorite provision of the bill deals with legislative security. All 10 of us typically will go to a conference called NCSL, National Conference of State Legislators. Uh, they've got a grant program right now for a little bit of legislative security, but in the bill, we provided authorization for lawmakers across the state to use their campaign accounts for some limited security. That's like an alarm system at your home. Let me start with the Democrat, Senator Bluen. His wife had all of the tires slashed on her car. We'll move over to the House. Kira Birkeland had security at her house, some really, really scary threats. Um, she had Highway Patrol basically living in her house for a couple weeks. I had three windows broken out at my law office. Mike Kennedy had his garage extensively vandalized. Former Senator Andrade had his two vehicles at his house. Every single window of those two cars were both ripped apart. I think of the 10 lawmakers on here, you wouldn't be surprised to know that a lot of us have received threats. The Speaker receives threats. The Senate President receives extensive threats. I'm sure Senator Weiler could give a list as well. But that's what the bill did. Again, least favorite part is the security, but we live in a different time, and I think it was important to do that. Any funding that we use from our campaign accounts, there is some grant money as well from from NCSL. So thank you, Todd. Any questions on that? Any follow-up?
I think you covered it. We're going to jump back to Representative Grant Miller to talk about Senate Bill 73, which is age verification. And I'll get that slide up on the screen. Grant, are you
Yep.
good to cover that one?
You bet. No, thank you, Senator Weiler. This one was an interesting one. When it came over to the House, I kind of perused it real quick. I'm like, oh, this protects kids. I'll vote for it. I didn't hear any opposition to it. Next day, I opened up the paper and realized that we passed a porno tax. So that's fundamentally what this is. It expands the ability of the Division of Consumer Protection to have greater enforcement priorities on materials that are harmful to children, and makes a more robust mechanism for age verification. And we're talking about like websites like pornography distributors, who that's going to apply to, creates a 2% excise tax on those platforms. And then that money goes into mental health resources and enforcement of the rule. Also kind of beefs up this VPN workarounds. A little bit of background here, and this was originally Senator Weiler's project. He originally created these age verification requirements for these websites. And after the law went into effect, major distributors of pornography just turned off services to Utah. And that same day, VPN access in the state just shot up dramatically. And so this law also has a provision that these distributors can't rely on VPN workarounds. And must establish firm age verification mechanisms. And I believe that pretty much covers it.
Yeah, thank you. And so, if the government doesn't like something, we can ban it, we can regulate it, or we can tax it. And so in this instance, we're taxing it. So it's as simple as that. All right, we're going to jump back to Senator Cullimore for House Bill 276, which has to do with age verification. I'm sorry, with artificial intelligence. I'll get that screen up next. Go ahead, Senator Cullimore.
So every year for the past couple of years, we always have a few bills that deal with AI and new potential liability that deals with the use of AI. This creates a cause of action against platforms that allow for somebody to go on and basically create uh, an intimate image, as it's called in the act, but basically a nude of a real life person without their authorized consent. And so it just spells out what that cause of action is, what the safe harbors are to avoid liability, to not hold yourself out as a platform that is exclusively used for that purpose. Yeah, so it's basically just trying to shut down revenge porn, but stuff that was never authorized or is even real. Another bill that we passed that it's not HB 276, but creates a cause of action that's somewhere between defamation and the commercialization of somebody using AI. So the thought was, if somebody uses AI and does something that can cause reputational harm or something like that, there's not really a good cause of action because you want to default to traditional defamation and libel type laws, but you have to demonstrate actual damages. And if they're not actually trying to commercialize the thing that they created using AI and it looks very real, but if they're not trying to commercialize it, then you don't have a cause of action either. And so there's this middle ground, and recognizing, I worked with a lot of really good attorneys, but recognizing that we're kind of operating in new legal territory, we may not have struck the right balance just yet. There's a lot of First Amendment issues that we had to try to navigate around. And so if it's clearly transformative work, meaning it's like for art or movies or something like that, or it's clear that it was not intended to be real, if it's disclosed somehow or something like that, then this wouldn't apply. But this creates a cause of action for basically reputational harm when somebody uses AI impersonating somebody else in a damaging sort of way. And so we'll see how that plays out. We may need some tweaks in the future, but yeah, there's going to be AI policy bills every session now.
All right. I'm not sure if I'm showing the right, is that HB 320, the other AI bill?
No, it was SB's.
Oh, it's okay.
It's an SB one. Yeah.
I do think it's interesting. The White House is trying to get states to back off of AI regulation. They want to do it on a federal level, which on some levels makes sense. Rather than having laws in 50 different states to comply with. But I do think there was another really good AI bill that did not pass this year because the White House was basically trying to
Can I
kill it.
speak to that approach, Todd?
Yeah.
So the balance that we've been trying to strike here in Utah with AI policy is to regulate where the interaction is with consumers. And largely up to this point, we've avoided regulating the underlying technology. I think we all have a collective guilt about not properly addressing consumer data privacy or not properly addressing social media harms, particularly the harms it's caused our kids. And so with that, we're saying, well, let's get ahead of this on AI. But I think there is a fundamental difference in regulating the actual technology and the development of that technology and not trying to hinder that, and then finding the right approach to addressing the output to a degree and how it actually interacts with consumers or the harms that can be caused. And so in Utah, up to this point anyways, we've tried to focus on that. And not that we're beholden to any administration or federal policy or anything like that, but I think the approach that we've taken thus far is pretty well in line with the administration's approach to AI.
All right, thank you. And I think if you don't mind, we're going to have you cover the House Bill 378 fugitive dust mitigation amendments, if you don't mind. And of course, because we're talking about fugitive dust, we've got Harrison Ford up on the screen.
Oh gosh. I don't think I was the floor sponsor to this, was I?
No, you weren't. I'm sorry. I texted you last night. So this one just requires gravel pits to post signage, including contact and permitting information at a visible place to the public. This was a request from our Division of Environmental Quality. All right. Thank you, Senator Cullimore. We're going to jump back to Senator McCay now for House Bill 84. If I can find that one, it's the dangerous weapons. I'll bring up that slide in a second.
Yeah,
What can you
and
tell
you're
us
good.
about that?
You're good. And this is one I didn't carry. I think I drew the short end of the stick as well on the draw last night, similar to Senator Cullimore. But dangerous weapon amendments came over from the House. It just reshapes what we do with weapons on campus, and it allows for permitless concealed carry on campus, age 21 and older, and open carry is largely prohibited on campus. Pretty straightforward bill, but that's what it did. And if anybody else wants to jump in, this wasn't a bill that I worked on, but again, 21 years or older, uh, concealed carry, but largely prohibits open carry of some of these dangerous weapons as well.
All right. And while we're on you, Senator McCall,
Yeah.
let's jump to another one that you didn't sponsor.
I
And
think I
that
did
is that's the Transnational Repression Amendments, House Bill
yeah, and
547.
I did carry this bill through
Oh,
the
I'm sorry.
Senate. And this bill is interesting. We've done a lot of work for those that have been paying attention. We've had a lot of concern with the involvement of foreign governments, and not just China. We often talk about China. The definition we use is we look at our entities and nations that are defined in the National Defense Authorization Act. But this bill is pretty straightforward. We've got a lot of students that come in from foreign countries, and it requires the Utah Board of Higher Education direct the state's institutions of higher ed to provide information on transnational repression to international students and how to report it. We also create a penalty. We've had several bills in this space in the past. Yeah, I always question when these bills come to me, is this a real issue? And when these bills come to me, I'm always shocked by the stuff that we see. I think we take for granted a lot of the freedoms we have in this nation, but that we really want to make sure our folks in higher ed are engaged in advising some of these students, and that's what the bill does. Good bill.
Thank you. Senator Stratton, can we jump to House Bill 69? What can you tell us about drinking water restructuring amendments?
Sure. House Bill 69 is one of probably 45 water-related bills that we handled in the session. We do have a great water system. We stand on wise shoulders that put in place protections when we have a year like we've had, that we can get through it and hopefully look to a better year as we move forward, and some good rain throughout the year. But 69, sometimes when we have some smaller water, generally it was hand tailored for the smaller water companies. If they're not meeting regulations, or if they're having financial trouble, it allows a receivership to kick in. There's certainly additional heightened elevated reporting legislature in that case, but allows a process to make sure that a company that's struggling or not acting in good faith, providing water, can be dealt with, navigated, and protect the water that is coming to those that it's serving. So that's the spirit of that bill.
All right, thank you. And then let's jump, if you don't mind, to Senate Bill 254, which is extracted natural resource amendments.
All right, I'll pull that up real quick.
I'm going to show it on the screen right now.
Okay.
This is critical minerals.
One of the great things to segue in, I have been, one of the big concerns I work, one of my assignments work a lot in our natural resource space. But one of the things that I've really been concerned about is the lack of our rare earth minerals and so forth available to us, and held primarily under control of those that may have adversarial, internationally adversarial intents towards the United States. We did find west of Utah Lake a treasure trove of rare earth minerals. It's in our Sitla property. It's remarkable. It's going to change the whole world global structure on rare earth minerals. But what we're doing here is to deal with the permitting process, to streamline it and move forward, to draw upon the great resources we have. We have, in the state of Utah, we have such tremendous natural resources. It's remarkable, top to bottom, side to side. And we need to make sure that we're being environmentally wise and stewards of that, but also ensuring that we're not hindering the progress of our not only our state, but our nation
Hey, Keven, sorry to put you on the spot. I really meant to go to Shallenberger on this one. So David, what can you
Dave, go,
tell us?
yeah, David, go ahead. Sorry, I called you first. Dave has that. Please go ahead.
Yeah,
Thanks.
sorry about that.
But I think that captures, I think, what we're doing, and Representative Shallenberger may have a little bit more to add.
No, Keven, Senator Stratton nailed it. And so this is a huge effort trying to bring all the different creative minds across the state, from the University of Utah, which is one of 11 universities in the entire nation that has a mining program, and pull in the mining association and the mines across Utah, inland port, really trying to build a mining hub where we can tap into the nation's need for these critical minerals. Because like I think Senator Stratton just said it, 50 of these 60 minerals are found in Utah, and Utah specializes in the mining, the processing, and the manufacturing. And so the goal is to provide help bring all these efforts together so that Utah is mining 20 to 25% of the nation's critical minerals, processing 50% of the nation's minerals, and that we're really leading the efforts for these resources that we have here in Utah, both the minerals and also the brain trust and the technology that we have in our businesses. So that's what this does, is it creates an effort, a committee to work together and help bring all this talent together and tap into the federal efforts that we need. So,
all right, great. And then David, can you also cover for us House Bill 437? It's on the screen.
Oh, yep. So this one we were working with the Division of Environmental Quality and DOGM, Division of Oil, Gas, and Mining. And it really, I think Senator Stratton was the one that maybe summarized it as this. It's sort of like TSA pre-check, or where you can, using a paralegal. So this allows, when people are working on environmental permits for whether it's nuclear processing or other types of permits, you can work with a certified, verified outside firm, an engineer that's been proved and vetted, doesn't have a conflict of interest, and they can do a lot of the drafting of and review work for a permit. And then when it gets to the Division of Environmental Quality, or DOGM or DEQ, all of the preliminary work is done, and they can review it for the substantive portion of it. And it saves a lot of time, a lot of money, and really streamlines the efforts for these agencies.
All right, thank you. Senator McCay had a little bit of an emergency today, so he's just joining us now, and he's going to cover a couple of bills for us. Senator, I'm going to show your bio, but why don't you just tell us very briefly, who you represent and where you went to law school and stuff like that, real quick.
Thanks. State Senator Dan McCay. I live in Riverton, and I represent the south end of the Salt Lake Valley, a little bit of the north end of Utah County. Let's see, I've been in the state Senate since 2018. And let's see, I went to law school at Willamette in Oregon. And let's see, that feels like so long ago. So,
and I did not know that's how you pronounced it. I'm so glad you said that.
Well, I'm here for you.
I would have said Willamette for sure. Well, can you kick us off with House Bill 242? This is the initiative and referendum signature gathering removal amendments, and I'll show it on the screen. I'll show the slide on the screen.
Yes, Senate Bill 242, right?
House Bill 242.
Or House Bill 242. Let's
see.
No.
Oh, that's not yours. I'm sorry.
I was going to say, I don't think that's mine, my friend.
So let's go to, okay, I'm sorry. My bad. Let's go to House Bill 78. Nuclear regulatory amendments. It was not your bill, but I was hoping you could.
Well, it's not my bill, right?
Yeah.
But basically, this set up the Nuclear Energy Office, within the Division of Waste Management, and really is kicking off this expanded effort for Utah to start looking at, not looking, but actually exploring ways that we can implement nuclear power. You saw the announcement that was just recently done with the governor and his team in Tooele County. And you've seen, a reactor actually came over, and we've actually been, the United States has solved this nuclear issue for, a generation or longer, and trying to find ways with the additional requirements for power, trying to find new sustainable ways to do that. And clearly, nuclear is the direction we need to go in for both the long and the short term. And so this bill just was creating that nuclear regulatory commission.
And I'm now showing, I think, Senate Bill 135. So this is a kind of a companion bill that also positions Utah to compete for proposed federal nuclear life cycle innovation campus. And whether you like it or not, Utah is jumping into nuclear feet first. And France has been powering most of their country from nuclear, but we're not looking to build a big nuclear reactor like 3 Mile Island or Chernobyl. We're looking at kind of the smaller module, like maybe a unit that would fit into somebody's bedroom size, but it would like maybe just power like a data center that it's attached to. Does anybody else, before we move on, does anybody else want to say anything about nuclear? Don't go nuclear on us, but
I'll jump in. I went out to the announcement with Governor Cox last week, and one of the things that was interesting that I wasn't aware of with this is we all know the energy solutions that we store a lot of nuclear material out in the West Desert. And the nuclear rods are just tiny little things. A lot of them still have the potential of 80 to 95% production power, production capability, but they're already spent rods, but still have 80 to 95% of the production capability. So the point of that whole thing was trying to work with our federal government also to create nuclear facilities that can reuse trillions of dollars worth of nuclear storage that we have out in the West Desert that can tap into that window of the 80 to 95% still usable nuclear rods and help use that and drain those down even more. So it's safe, reliable, but we're sitting on a gold mine, a nuclear gold mine out in the West Desert.
All right, thank you. Senator McCay, since we've got you, let's jump now to your tax cut bill, Senate Bill 60.
Yeah. This is, you saw other states in the country. I mean, interestingly, gosh, it was 6-7 years ago, states like Arizona and some of the others, they took full percentage leaps. So they started at, if I remember right, Arizona was something like 4.5%, and they dropped the rate. And let's just forget that number for a minute, but they had a number, they dropped a full percentage point. Utah has taken a different approach where we have, we started at 5 and we've slowly been, moving into or reducing our income tax. And we feel like that's a conservative way to do that as we're budget testing. We're stress testing against our budget to make sure we can still meet the needs and requirements of the students and the needs of the state with those funds, but then at the same time be able to, in a very conservative manner, continue to reduce income tax. And I feel like, in a lot of ways, people say, well, why would you do income tax instead of others? And let me explain that just very briefly. Income tax is actually, of all the taxes that we collect, it is the one tax that, the public reports that they feel like more people are dishonest on, which is interesting, because when you think of the cost of compliance, we have auditors at both the federal and at the state level that are constantly reviewing these returns and auditing those returns. If you think about the information you have to put onto an income tax statement, it's a very revealing type of tax versus you compare that to something like sales tax, where when really the only thing the government knows is how much you paid for whatever it was that you purchased. And that tax is very transparent. You know when you're paying it, how much you're paying it. You can choose how much you're going to pay. And the government only gets to know what you paid for it versus the government gets to know a lot about you as a result of the income tax. So there's been this push to try and figure out other ways to continue to get rid of that income tax. The other part of it is once you pay income tax, every tax you pay after income tax becomes a double taxation, where you sales tax after income tax, it's a double taxation. Now, there are SALT deductions on income tax statements, we'll keep it simple for our purposes today. But that's, those are some of the reasons that we've looked at removing the income tax and continuing to find ways to remove the income tax. And we're trying to lay out a roadmap to continue to be very competitive in the state. We need to really be down in the threes to be competitive with the rest of the country as far as economic development goes.
So 30 more years and we'll get there.
I'm not going to be around that long, Todd. And we're going to get there before I'm done.
Okay. Thank you, Senator McCay. He is one of the tax experts in the legislature, and I really appreciate that because I am not a tax expert, nor do I want to be one. We're going to jump back to Senator Brammer now for House Bill 540, which I meant to do with some of the other court bills at the beginning, but I got mixed up and I skipped over it. So, Senator Brammer, what can you tell us about House Bill 540?
Yeah, so for all of you out there who just love exchange with the courts, I apologize. This will probably kill exchange, but it will replace it with a much better system that allows for 50 searches of downloads for free.
Is that per year, 50 searches per year?
Yes. And then the court can charge after the first 50. And then it also requires the courts to maintain audio recordings that parties should be able to access for free. So now you don't have to do a specific request. The biggest thing, the courts, when it first came up, the courts are worried because their IT systems have not always been the best. And so we were saying you need to hire a third party you need to use a third party vendor for this system for the court records. They really requested that we accommodate them to do it in-house. And so we've agreed to do so. This puts a lot more funding into the IT back end of the courts. And so a lot of these changes, go ahead, Todd.
I was going to say, I think I just cut you off inappropriately, but these changes will not take effect until next January.
Yeah, so they'll have time to build out their system and hopefully beta test it pretty well. But a lot of the changes to the court came with more so I manage the budget for the courts and the prisons and the AG's office and like highway patrol. But I don't think the courts have ever received as many resources as they received this year with the additional judges, with the revamp of their IT, and we've been working pretty well with the courts to try to help update, help give them the resources they needed to administer justice. And so we think that that'll be a good one. And then I think I have the next bill as well.
Yeah, SJR1. Go into that one.
Senator Brammer, can you
Go
also
ahead.
cover the recording aspect of this bill?
Yeah, parties will be able to get the recordings without requesting. I don't know if there's another part of that you wanted.
No, that's all.
Okay.
So SJR1, what that one does is it is a modification to the rules of evidence. So in a sexual assault case, if you are a juvenile or if you are in federal court, there is a set of rules. If you're a juvenile in state court or if you're a juvenile or adult in federal court, there's a set of rules related to previous allegations. But if you're an adult in Utah State Court, it is a different set of rules. So what this does is it matches our rule of evidence with regards to prior allegations to those of the federal system and then also to the juvenile system. And so this should have a pretty significant change in those prior instances of sexual abuse within the state.
All right, thank you. Representative Miller, we're going to jump real quick to solar panel disposals. What can you tell us about that?
Yes, bill passed into law that creates a study on how to better dispose of solar panels. Solar panels can cause tremendous problems with the toxicity if they're not disposed of correctly. And so it creates a study plan on how to deal with it because we're going to have to start dealing with more and more solar panel disposals. Also creates a significant fine that caught my attention. It's a $10,000 a day fine for small organizations that don't properly dispose of solar panels. And I talked to the bill sponsor because I was concerned about that, but evidently that's matched to some industry standard. Moral of the story is don't throw your solar panels in the garbage. They do tremendous harm to the environment. And if you run a business for some reason, you moonlight after you're done litigating as a lawyer, and you dispose of solar panels, please be mindful about the way you dispose of them, because the penalty for just throwing them in the garbage is tremendously steep. And I think that just about covers it.
Turns out clean energy isn't as clean as we thought it was. All right, Senator Cullimore, can you talk to us about Senate Bill 217, local food amendments?
Yeah, this just provided a little bit of clarification on homegrown food. We've got a fairly thriving economy here of local producers that go to their various markets across the state. But we have some restrictions that if you produce locally grown food, you have to be the one that sells it. So this just expands it a little bit and says that they can contract with other people to sell it. This would expand their ability to sell to multiple farmer markets, maybe even create co-ops. And so it just helped locally grown food to better get out to consumers across the state. It also provided a little bit of clarification on what's taxable and what's not. Currently under code, it's a little bit ambiguous, at least the application of sales tax on these types of food products. If you produce something and it's just, wholly grown vegetable or local produce, it's not taxed. But if you change it, it change its nature in any fashion, like if you put honey in like a cute little bear jar or something like that, all of a sudden that has to be taxed. And so there's some discrepancy in what was getting taxed and what not getting taxed in local farmers markets. And so we just try to clarify that and say, basically, none of this food is subject to tax, and unless it becomes more commercialized.
All right, thank you. I did not think we'd get through this slideshow, but we're almost there. Representative Abbott, can you talk to us briefly about Senate Bill 206, tax amendments?
Yes, I'd be happy to. So SB 206 made some changes to property tax. And essentially what it did was there's been some concern about tax creep. In other words, as population grows, municipalities or counties increase the amount of tax that they receive without actually going through a tax increase in a transparent way. And so this doesn't completely abolish that, but it eliminates the abilities of cities and counties to continue doing that in the future. So they'll have to, if they want to capture all of what they've captured in the past, they'll have to do a truth in taxation hearing and kind of go through that process. It makes some changes to how we've had a problem in the past with some of especially the smaller counties with their expertise in doing appraising on complex properties and that kind of thing. And so we've had a statewide trust administered by the counties that's kind of helped provide resources to all counties, but especially more rural counties. And we've changed that. Instead of having a trust that's administered by the counties, that is now becoming a state-run or state-supervised program. And then finally, we've made some changes to the reporting and the transparency for tax increment financing. And so this has become a bigger and bigger issues as the number of these entities grow throughout the state. And there's been some concern that they're not as transparent as they should be, especially given the fact that they are getting tax money. And so this creates transparency. So the reason it might be important to some of you is that it is estimated that this will reduce property taxes statewide by $17 million. And if your home is worth $500,000, you can hope to receive $9 every year in tax reductions. So congratulations.
There you go. All right. And last but not least, Senator Stratton, in the 1 minute we have left, what can you tell us about your Senate Bill 304 protective order amendments?
Thank you. As we know, when we deal with protective order, this is a very delicate area. We've got to protect those that need it, and that's part of an overriding principle. But all sides on this agree that there's times when there's abuse. What this does, it puts in place an opportunity to raise those concerns where false accusations are made. The court can take action. And also there's an opportunity where time with children has been lost as a result that can be made up. That's a quick summary.
All right.
It does come into play though. We did extend it a year, so it's a 2027 coming into law. We wanted to give ourselves time to address any concerns between now and then. So that's it.
Ken is asking if we can get a copy of the slides. I'm going to put my email address in the chat if you want a copy of the slides. I know there's like 400 of you online. Email me and I'll send them to you. Unless, JC, is there a better way of doing that?
I believe we have a list of who participated. We can have the
Okay,
bar
I'll
email
send
those
you a
out.
Senator
final
Weiler,
copy.
if you email the slides to me, we can send them to all attendees with their
Okay, let's just
certificates
do
of
it that way.
attendance.
JC, any questions you want us to cover? I guess we're out of time, but any
No,
last
I
thoughts?
think we've been able to answer most questions through the chat. I have a couple things to follow up on, but we're at the end of time. So I do want to thank each of you for participating and all of the bar members for joining us today. As you can see, there is a lot that happens during the legislative session. These folks do not have easy jobs. And while the bar's positions on things and some of our legislators don't always line up, I do want you to know that they work really closely with us. And a lot of this legislation that we've talked about today has ended up in a much better spot because of their willingness to work with us and listen to us and move forward with things. So really a huge thanks to each of you for being here today, for your work, and for your work with the bar. And thanks everyone for joining us.
Thank you. Thanks, everyone.